Order for another update, Kessie and Abetu Jam, so beginning in Abro, I will Ghanatube. Kai say, Sisi Amena Okasano, Gertrude Torkornoo, the dismissed or sacked Chief Justice. We journey at the ECOWAS court. Say Ostro Moa or Monka na Assembly Bimano, na ruling in her favor. Order for HSA, Attorney General's office, and so at the information Kessie Asanswaba. Almost say, almost file another case and so the ECOWAS say also be cancel many case no say also the case also ruling in favor there and the Ghana says so Attorney General's office almost the court case be ECOWAS so now almost makoko stande Gertrude Torkornoo in case no for just in same way the able to made the far say na Attorney General Ghana say Attorney General some the far or the far no more the just say omo pese maame onko bebia no koda onko ni fie no koda bae maame to si da bi opese ECOWAS court no ekasama no en Attorney General's office omo so mababo ntin say omo so ombe file default case against Yankase maame Gertrude Torkornoo the sacked or dismissed Chief Justice order for umenko nyanko ji sansem we nyina nchire mu Ghanatube member isia.
But our preliminary thought is that if we are objecting to the jurisdiction of the court, and the court has taken argument and has adjourned to give a ruling one way or the other, we do not exactly think that we have to file on the substantive issue, because the question before the court is whether the court has jurisdiction. The court has to clear that aspect first, and when it says that it has jurisdiction to assume, then they will order us to file our defense. And indeed, if the court was interested in getting the court could have ordered that we should file our defense together with our preliminary objection, because we were heard. It's not as if we argued that matter in court, in the ECOWAS court, and we were heard. And the court in adjourning didn't give any further direction. They told us that they are rising, and then they have adjourned the case, indefinitely. And when they come back, they will give us further directions. So we were waiting for the court to give us further direction, only to be served with a notice for default of defense. So that is where we are at the moment.
So what are the next steps? You'll be applying for that to be thrown out as well?
Yeah, we would have to file to oppose the application for default judgment, because, like I've explained, the court did not order us to file our defenses.
You're a legal scholar yourself. I mean, the outcomes of that court decision, we know how our jurisprudence operates. Does not, even if we sign treaties, it do not automatically become law here. I mean, the outcome of the decision, whatever decision will come from the courts eventually, how do you see it playing out here in Ghana?
Yeah, so currently, because the ECOWAS court has not been incorporated into our legal system, the decisions of the courts are sent in to us here in the Attorney General's Department, and it's an executive. Within the framework of government, we have the executive, the legislature, and the judiciary. The fundamental principle is that in dualist countries like Ghana, the courts do not see international agreement unless they have been ratified by parliament into domestic law. Then the courts can see it. So the Supreme Court, technically speaking, cannot see whatever, or is unable. All the courts in Ghana are, let me put it literally, they are unable to see what is happening in ECOWAS, because we have not domesticated the ECOWAS. However, governments can decide. That is, when I say government, I mean the executive. When it is served on us, the government of Ghana as the executive may decide what to do with the decision. And that is not to say that I have predicted what government of Ghana would do. Government of Ghana would decide whether to grant the award, or, I mean, if the court grant the award, whether to pay or not to pay. Whichever way, the ECOWAS courts can hold the government of Ghana to not comply with the decision, because we have signed an agreement. So at the international level, the ECOWAS court is also not aware of the divisions we have in Ghana's executive, legislature, judiciary. They are aware of government, I mean, Ghana as a country. So if they give a decision in that court, they, as far as they are concerned, the decision must be implemented. If we do not implement it, it could be enforced at the ECOWAS court. But the courts of Ghana are not aware of these things. I'm saying it in a very vivid form. They are not aware, or they don't have what it takes to see what's happening in ECOWAS because Parliament has not yet opened their eyes to what's happening in ECOWAS. So it's a dualist situation. We have domestic law, we have international law. A lot can happen there without coming into domestic law.
A more direct, simple question for an ordinary man. In the event the court, one of the preliminary measures she was asking for was that she should be reinstated when the suspension was in force. If the court says she should be reinstated, what will happen?
We'll cross the bridge when we get there.
And finally, on this CJ matter, I mean, do you think the entire Article 146 procedure needs an overhaul? Particularly, the problem sometimes is.
Order for anyamna mekan you want some in seminar course no. Just a way information kesi efi the office of the Attorney General. Yes, say omonso omobe file e the oppose application now. Eyeye maame or the ECOWAS court say of a default judgment no say dabi. Say ye maame the case ne ko ho dia omonso ombe file no be oppose sa application no for default judgment. Order for anyamna mekan way office of the Attorney General information kesi efi ono mo a edia ba say ye maame de bebi obefa bia no ombedi nechi so the fine you upon we American court ombedi nechi bebi obeko bia no ombedi nechi je say NDC for a crowd say maame die once I dismiss no anaya sake ne die onko fi no onko tena no nda odofo when I breaking news abeto dua me so bedi ni na bre e wo Ghana odofo manko nine santu ansem no so ma isi a Ghana so
the judicial decisions, which some say that has complicated things to the extent that even though they are reading into the law, they do not provide clear text how it takes place. So they make reference to the Gertrude matter on prima facie determination. So it has put it in there. It doesn't tell us at what stage should a person be heard. Is it before? Is it when the president receives it immediately? Do we need to have a clear overhaul just to make things more predictable?
So I believe in a living constitution. What it means is that the constitution would undergo reviews either by legislative measures, by judicial decision, or even by practice. You know, these are some of the ways that constitutions grow. The fact that constitution can grow, the fact that we think we can improve our constitution, doesn't mean that what we have is terrible. You understand? So, for example, if the argument is that the process is not detailed enough. Of course, we can make constitutional instruments or we can make other laws to detail out the process, which is fine. What I do not subscribe to is to say that because of want of that, what has been done is wrong and is unfair. You know, that is where I have a problem because you can't tell me that, for example, you said the Constitution didn't give the specific number of days that you should return a prima facie decision or the specific number of days that the committee should conclude its decision or the details. So because of that, then whatever has been done is unfair. That argument doesn't wash. But if we say that, okay, we have gone through a process, we have identified a few things that we can improve upon. So let's take steps to do it. Fine. But that does not invalidate that which has been done under the law as it is.
Let's talk about Oral now, Operation Recover or Loot, a big campaign promise before the government came into office. Almost 9 months down the line, 2 cases, the SkyTrain one, and the other one involving the former National Signals Bureau chief. Would you say Oral is on course?
Oral is very much on course. It's so much on course, and sometimes I look, you know, as I sit here, I look at the Ghana Police Service, I look at Yoko down there, and I see BNI on the other side, and beneath where I sit are hundreds of attorneys, and they're having sleepless nights, you know, investigating. So let me take this opportunity to explain the process of the criminal procedure to the public. I think when I do that, it will at least let the public know what is going on so that the allegation that or the complaint, I understand the complaint, okay? Because so much, you know, a lot happened in this country, the citizens became aware of it, and they are eager for justice. And I understand that, and I subscribe to that eagerness. And actually, I get, every morning, I get not less than 100 tags on social.
Odofo when e breaking news abeto dwa me so be gini nyina brɛ e wo Ghana to just say Gertrude Torkornoo and ECOWAS case no de akono e na yesi chale baby o de befa bia na ye bedi nechi odofo anyam na me kan we office of the Attorney General information case no mde abeto omo say omo so be file case e we ECOWAS course nobody akọ oppose eye yankase ye maame ni case no da koto seeking for a default judgment odofo when e breaking news abeto dwa ye say Ghana for ye court anasi Attorney General so ombe file case e de akọ oppose sa application odofo when e breaking news abeto dwa me so bi ni na bro e wo Ghana to odofo ma remfi say mobile like no ma subscribe no ma share no ma hit notification bell so ma say de be ya bring ya bibia do pe content say ya wo nya ne tempa no atwe no item odofo aha ena me de nsem nyina besi Ghanatube so makra mu nyina beda mu nyina se bebre